A surety hearing basically is when a person is accused of obtaining his money from illegal means. It started originally for people that were alleged to have engaged in the drug trade, but sometimes the district attorney's office tries to demand a surety hearing for people involved in credit card scams, counterfeit money crimes, and other areas of law. But it's when they demand basically to know what's called the source of the money. So typically speaking, what happens is if a person has a $50,000 bail set, the person wants to pay 10%, they can just bring the $5,000 and pay the bail, and the person, plus the premium to the bail bondsman, and the person can get out. Or if they had $50,000, they can just pay the whole bond, and the person gets out. But in a drug crime, the district attorney's office has moved for the court, the judge, to issue what's called a surety hearing, in which the person has to show the source of the money. It's also known as a bail source hearing. Where did this person get the money? That's the question that's fundamentally being asked at a bail source hearing. So oftentimes the clients say, hey, what is this surety? What is this bail source hearing? And how can we get my loved one out of jail on bail? The first step that I take is I thoroughly interview and vet the potential client in tandem with the bail bondsman if they're going to pay the 10% route plus the premium. And then if I determine from my experience that it's something that should be acceptable to the district attorney's office, generally speaking, I'll try to contact the district attorney's office, convince them not to proceed with the hearing, and have them contact the court to just allow to okay the bond, and then have the court just sort of okay it on that day and then let it go through. Obviously, because people are so anxious to be released on bail right away, obviously if I don't get a hold of the district attorney's office, if they play any games on the phone, we just go ahead and put the money up and prepare to go to the hearing. But I can tell you that the vast majority of cases, because that I've had, I know the different offices well, and I move quickly on my cases involving sureties and bail source hearings. The vast majority of cases that I've had, we haven't had to start, even so much as start the hearing, because I know what the district attorney's office is looking for in terms of a bail source, and I know how to pitch the argument to them, so they're not going to go ahead and proceed to the hearing because they'll know they'll lose. That's typically the first type of question I get, and the important thing is just to get the documentation that I require to show the source, and for us to move quickly to get the loved one out on bail as soon as possible.